Friends, I would first like to thank the President, the General Secretary, and office bearers of APDR for inviting me to deliver the Bhattacharya Memorial Lecture. The Indian Penal Code, the Criminal Procedure Code, and the Indian Evidence Act has a life of exactly 31 and a half hours from now. It's 4:30 today. 31 and a half hours is all the life that these three laws which govern India for the last 160 years is going to have. From day after tomorrow, Monday, a new set of laws are going to come into place. And in my assessment and in the assessment of the PUCL, these laws are not just dangerous, they are going to destroy the entire basis of criminal justice system in the country. They are going to completely change what we know as a justice system, especially in terms of expressing our right for democratic protest. We will be entering into a land where meetings like this, meetings that you have called me to talk to you for, can become tomorrow either seditious or it can become a terrorist offense, and all of us can be put inside. That is what the law that they have brought about, which is going to come into effect from Monday, 1st July 2024. So it's at a very apt time that APDR has organized this meeting, and it shall be my endeavor to share with you all how we are reading. When I'm saying I'm talking about PUCL, because as General Secretary of PUCL, as also somebody who's been working on this for 35 years, I have the weight of the organization behind me to talk about the impact of these three criminal laws. There are two issues that we need to keep in mind. One, what was the need to completely throw out these laws and bring new laws? Is the need justified or not? As members of Kolkata and people who are interested about civil liberties, human rights, constitution, this is a very important question to ask. Because you have a right-wing media which is saying, these laws are important, very good. These are all old colonial laws. We are now an independent country. Our national interest has to be there, and therefore we need to throw out those laws. The police commissioner, a senior IPS officer of Mangalore, has come out with a 2-minute video film. I don't know how many of you have seen it. And he talks about this is a great revolutionary leap forward. The National Police Academy, the various police academies throughout India are saying, finally we have a law which is going to be very good to ensure that law and order is going to be kept in place. Friends, this is a total lie. This is not just an ordinary lie, it's a total lie. Let me give you an example. The Criminal Procedure Code, originally written in 1861, was completely changed in 1973. So the law that they have changed today is not a colonial law, it's an Indian law. They've changed. In 1973, they changed. For 2 to 3 years after 1973, there was a lot of confusion. It was an old law changed and come out in a new garb. Now they're throwing out the old laws and bringing out new laws. You can imagine what chaos is going to come. Secondly, Indian Penal Code has been constantly amended. And Indian Evidence Act has been constantly amended based on Supreme Court rulings and based on the discussions and debates taken up in Parliament, outside Parliament, by civil society groups. Therefore, the question comes in, what is the true intention behind the change of those laws? And that is what we shall see now. What is the true intention? Just a few figures, because the present government is thinking that we are all stupid people and we can't make a distinction between what is a law and what is going to be the consequence. The law was first introduced, these three new laws were first introduced in Parliament in August 2023. There was a lot of ruckus, a lot of opposition to it. They sent it to a parliamentary subcommittee. The parliamentary subcommittee submitted detailed reports and gave it back to the government to say these are the type of changes that should be brought about. You will be surprised that the parliamentary subcommittee headed by the BJP, with majority of people from the BJP, spent 2,595 minutes in discussion. 2,595 minutes is 43 hours and 15 minutes. In all, they have discussed 43 hours about these three new laws. When you calculate the per section amount of time they had to discuss, it works out to 2 minutes and 45 seconds discussion time for one section. Now, please imagine the old IPC, CRPC, and the Indian Evidence Act totally had 1,162 sections. They have been replaced by the new Bharatiya Nyay Sanhita, Bharatiya Nagarik Suraksha Sanhita, and the Bharatiya Sakshya Adhiniyam with 1,059. Effectively, 2,600, approximately 2,600 sections have been changed, adapted, etc. 2 minutes 45 seconds is a time that has been given for discussion. Now, I don't need to tell, you don't need to discuss. Is it sufficient time for discussion? A law which is going to change the face of India from Monday? It's a question that has to be kept in mind. Because today they are saying, we have had discussions, we gave time for discussion. What is the time they gave for discussion? In December, 146 members of parliament were suspended. You all will remember that mass suspension that took place. All the political parties had boycotted parliament. That is the time when they introduced these three laws. And it got passed in a voice vote. It got passed as though it had a unanimous majority support of the parliament. This is the discussion that went behind this law. It's for us to say, was this enough or was it not enough? This is the trick that they have played. So on the 13th of December 2023, the law was introduced in Lok Sabha. Within 2 hours, it was passed. Next day, it goes to the Rajya Sabha. With not much time for discussion, it got passed. 25th of December 2023, the President of India gave assent to these laws, which means it becomes now the law of India. The next step is to implement the law. For that, a notification in the government gazette is required. Any law, the date of implementation is required. It cannot become a law only because President has given assent. The CAA, for example, the rules are not yet been fully notified. There are many laws like this which have been approved by the President, but notification has not taken place. Now look at the trick that they played. On the 16th of March 2024, Election Commission announced the dates of elections. Starting from 19th April till 1st June 2024. The dates are important. 16th of March, Election Commission has announced the dates of election. The notification for these three laws has not come on the 16th of March. So it is logical to think maybe the government does not want to implement the law. On the 23rd of March, 1 week after election dates are announced, the government notifies this law and says this law will come into effect from the 1st of July 2024, that is day after tomorrow. When the notification came, the police department, the revenue and the administration department, the political parties, civil society groups were all now involved in the elections. Because as civil society groups, this was an important election for us. It was an election in terms of a majority right-wing government which is going to come, which has already said, we get 400 par, we are going to change the Constitution of India. Okay. They were very clear. And there's the other group which said, we cannot allow this to happen, we have to fight for it. So activists, political parties, lawyers, the police, administration were all completely involved in the democratic process called elections. There was no time to think about these laws. 4th of June 2024, election results were announced. At that time, they first said, until the 3rd it was said, BJP is going to come back in power with more than 370 to 400 seats. On the 4th, we saw what happened. The government has come back without its majority. So effectively, from the 5th of June till today, that is 25 days. Tomorrow you add 26 days. The country has had only 26 days to prepare for the change to a new system of law. Now, it is up to us to decide whether this was sufficient time or not. In our assessment, this is not just ridiculous. This is playing with fire. And the only problem is, the fire is not going to go to the police. The fire is going to come to us. And yet, our voices have not come up in great opposition. We need to come together. And I will explain in the next part why it is very, very important that we need to come together. These facts I wanted to give, basically to say, this is the context in which we have to now understand these three laws. Okay. And this is the situation about what is going to happen in terms of the laws. Friends, we have no time to lose. Even if on the first they declare that they're going to go ahead with the law, we will have to hit the streets. We will have to oppose. We will have to object. We will have to condemn. We will have to come together in all non-violent, democratic, constitutional means to fight these three laws. Now, let us look at the changes of the law from the viewpoint of the victim and from the viewpoint of the accused. After all, criminal justice system is premised on the fact that any injury on any person has to be set right. The criminal system will come, not muscle power. The legal power will be used to provide justice. That's the basis of the system. So let us look at what has happened in terms of victims. What are the changes? Let us look at what has happened in terms of the law relating to the rights of the accused. Okay. In four broad areas. Okay. Let us imagine a criminal context. There is a crime that takes place. Somebody beats up somebody, somebody hits somebody, somebody steals something. Anything can happen. It's a crime. Now, we need to understand one thing, that the law defines the crime. Law will say this is theft. Law will say this is murder. The law will say XYZ is a crime. The responsibility of implementing the law, unfortunately, rests with the police or the state. Now, this is a very important concept we need to understand. The law defines the offense, but the state defines the offender. So when the Prime Minister of India in Rajasthan talked about Muslims in a very derogatory way, nothing happened to him. At that time, he was not Prime Minister. He was the head of the BJP. He was making an election campaign. He should have been arrested. You and I, if we talk like that, we will be arrested for creating enmity between communities. The reason for this is that the decision whether to file a FIR or not is with the police. In other way, police is only an extension of the state, and therefore the state. The first principle we need to understand, whatever the law you may say, ultimately it depends upon the political state, the executive, to implement that law. This, please keep this in mind for the rest of what I am going to say. The law as it is now says, if I am a victim and I go to the police and give my complaint, the police will have to look into my complaint and say, is it an ordinary fight between some verbal fight between two people, or has some serious offense taken place? So this in legal terms is called cognizable offense. That is an offense in which police should immediately take action. I am putting it in very simple terms. The lawyer friends I can see here, don't come back and tell me you are supposed to be a lawyer, you are giving some stupid explanation. I am giving a very simple explanation. An offense which is considered serious in law, that the police should immediately come and take action against the person who is accused of that crime. That offense is called a cognizable offense. In Indian law, going back from British time until now, until today, the law says that you can never trust the policeman. No state in the country you can trust the policeman. That is why the law says a confession given to a police officer cannot be used as evidence. Because in our country, you know what happens when you arrest and take to court, take to the police station? They beat you up, they torture you, they take money this side, they take money that side. Therefore, you can never believe the policeman. The law is very clear that if the complaint you make shows that it is a cognizable offense, the police has no option but to register a complaint, and the registering a complaint is called FIR. So if it's a cognizable offense, he has to necessarily register the FIR, which is the starting point for investigation. Okay? Because only the police has given the authority under law to investigate. Now this is a very simple understanding. This is the law. It's a law till tomorrow. This is going to change on one day. The Supreme Court has said there are many complaints throughout India in high courts and Supreme Court where people went to the court to say murder has taken place. For political reasons, the police is not registering complaint. One theft, dacoity has taken place. You give a complaint. Police is not recording FIR, so you have to go to High Court and file a petition. Say, please register a complaint. I have a case in which I won in the High Court after 2 rounds. Direction to register FIR in an SCST case after 19 years. For 19 years, the complaint was kept pending. I went to the court, we could fight it. Now, how many people can wait for 19 years? This was a case of custodial murder. Okay. Likewise, so many offences are there. So, Supreme Court finally came in 2014 and said, the law is very clear. If the complaint shows the cognizable offence, you have to register an FIR. You don't have any authority to say, I will not register an FIR. You have to, what is called technically, mandatorily, compulsorily, register an FIR. Registering FIR does not mean it's the end of the question. You have to investigate. After investigation, if you find that the complaint is false, no evidence is there, you can say, I've investigated, I'm dropping the case. What the new BNS, let's say the new IPC and the new CRPC, BNS and the BNSS is saying is that may be the law by the Supreme Court, but we are not going to follow that law. Now, instead of saying we will not follow the Supreme Court ruling, what they have done is they have taken that law and thrown it out and come up with a new law says that if the complaint that the person gives shows the offence of where punishment is between 3 to 7 years. If the complaint is between 3 to 7 years, then the police can conduct a preliminary inquiry. You don't need to register an FIR. They have given some conditions saying 14 days you can wait. You have to get the permission from the DYSP. Now we know how the police operate in this country. For the first time in law, they have given now power to the police to say, I will only register I will not register a complaint. I will take it as a preliminary inquiry and conduct the preliminary inquiry. The Supreme Court said preliminary inquiry can be allowed only in a few cases, like corruption case, like matrimonial disputes, or cases where complaint has not been filed for 3 months, 6 months, suddenly somebody goes and files a complaint. Only in those cases, Supreme Court said, while the compulsory rule is you have to register an FIR, exceptions are in very small number of cases. What the law now makes is the exception has become the rule and the rule has become the exception. The rule now is that from first onwards, preliminary inquiry can be taken up by the police. Now there are 3 problems here. 1, only complaints between 3 to 7 years. Now why only 3 to 7 years? What about complaints below 3 years? What about complaints after 7 years? Now supposing there is a murder, there is a rape or something, they are very, very big ones, you can't cover it up. There this law will not apply. Then the question therefore comes, why did they choose to change the law for offences between 3 to 7 years? Friends, I would like to tell you, 40 years I've been a lawyer, civil rights lawyer, criminal side, and also constitutional lawyer. Bulk of the cases of the ordinary people of the country are offences involving 3 to 7 years. So all the cases that ordinary citizens, slum dweller, demolition is taking place now in Kolkata. Okay, and you want to go file a complaint against XYZ, including the police officer. Can you go and file is a question. Right now you can file. From Monday onwards you cannot file. Because now they say 3 to 7 years preliminary inquiry. Now when will the preliminary inquiry be done? If the police officer says, I don't accept the inquiry, I want to drop the case, then what is the remedy for the citizen? So that is the first case. I hope I'm clear in this. Now, the law as it stands till tomorrow says, if the police officer does not take your complaint, what you can do is to give a covering letter and send the complaint by registered post to the Superintendent of Police. Question is, what if the Superintendent of Police also does not file a case, does not accept the case and directs the inspector to file a FIR? Then the provision is you have to go to private complaint. That is the law. We'll just keep that for a moment. So the only option for a citizen who is a victim, police do not register a FIR, is you have to go to the magistrate court and file a private complaint. Now take the other way. Preliminary inquiry. Supposing the officer says, I am not convinced at the end of preliminary inquiry that this is a criminal case. I am not taking it up. The law until tomorrow says if the police officer decides he will not take up a case, he has to give it in writing to the complainant or to the person who is informing. He has to give it in writing. Now in this new law, they have removed that. The police officer does not have to tell the informant, the complainant, that you have given a complaint. I am not convinced about the complaint. I will not take it. So I will not know the fate of my complaint. It is still there. Now after some time I go fight, and then I take back the complaint and then say, oh, maybe I should go up by a private complaint. So both the track is coming there. If the police officer directly does not take my complaint, I send it to the SP. SP does not take it, I have to come by private complaint. If this 3 to 7 years, if they go that way, I am still coming back to the same point of private complaint. Now look at how they've changed the law. In private cases, till tomorrow, the law is that if I file a private complaint against, say, person A, I can go to the court and say, I gave a complaint to the police did not take it, I sent a covering letter to the SP did not take it, so please take my case. I have a crime, I'm a victim, please take my case. The magistrate, if he thinks my complaint is genuine and I provided evidence before the court, the magistrate can then tell the police, you now register a complaint. Now it's a judge, it's not a police officer. Judge can give. Till tomorrow, that's a law. Now they have changed that law. They said too much power to the magistrate. They are now seeking accountability. Let's remove that. What they have now done in the private complaint is that if you file a private complaint, from day after tomorrow, the rule is that notice about the private complaint has to be given to the accused people. Now you are going to the police because somebody has violated your rights, somebody has caused harm to you. Now the court says, I have to give complaint to the person who has attacked me. Where is justice in this? Then I have to give him, the court will give him notice, he will come and file a counter, only after that they will take notice. Only after that, if the court is convinced, the court can say, I am going to take it up as a criminal complaint. Now friends, this will never happen in India. When I am giving a complaint, till tomorrow the law is, the court will only ask me to provide evidence. If the court is convinced, then the court will involve the other person as an accused and give notice saying, Suresh has filed a complaint against you. This is the evidence that he has brought in. Now you have to come to the court and give whatever evidence you want to give. That's a law that has been changed. The question is, therefore, how just is this procedure? The whole thing is oriented towards making sure victims can never go to court. That is one. Two, in the private complaint, supposing you are making a complaint, I went to the police officer, inspector, Thana, he did not take my complaint, he beat me up or he shouted at me and I went out. Okay. Now the new law says, if I file a private complaint against a public servant, the court will ask for two reports. The court will say, let the officer against whom you are complaining, ask him to come and give his reply as to whether my complaint against him is right or wrong. 40 years I've been in human rights field. I can tell you with that one, there's not one single case in India, in any state in India, where a police superior officer has come on his own and told the court, yes, my subordinate officer has violated the law and has affected somebody. It will never happen. It can never happen. So now the law has been made in such a way that it is now favoring the police and not the victim. But the reason they brought this law is to make it victim-centric. Where is the victim-centric in this? You make your own mind as to whether this is victim-centric. I am deliberately not giving you section numbers. Please believe me, everything I can give you the section number. I've written about it. It's been circulating. I'm just not giving the section number because the number of lawyers are here. Section 173 of the new BNS, okay, talks about it. Now, they have introduced one level of confusion here. You go give a complaint. How should the complaint be? The current law says it can be oral or it can be written. Now we are a modern country. where electronic things are there, all those things are there. So now the government is now claiming we are such a progressive country. You can file what is called a zero FIR, okay, or you can file what is called a EFIR. Zero FIR means that irrespective of the place where the offence took place, supposing the offence takes place here, okay, and you are beaten up and you are running away and you go to Dum Dum. I'm not familiar with, so I may be wrong in the area, but I'm saying you're going far away from this area. You're going to Dum Dum, which is a different police station. You give a complaint to the Dum Dum police station saying that I was staying here, this meeting I came for APDR meeting, one group came and beat me up saying, how can you go there? I ran away to save myself, I've come there, I give you my complaint. The law as it is now, there is no clarity in the law as it is now. Then they say you go to the jurisdiction police station. Okay. So for the last 10 years, Supreme Court has said, you don't need to look at jurisdiction. Wherever you are, you file a complaint there. It is a duty of that officer to send it to the correct police station. This is nothing new. This is there in the law. Supreme Court has talked about it for the last 10 years. It's called the zero FIR. About 5 or 6 states in the country already have zero FIR. Now this government for this law is saying, we are great. We are now giving you zero FIR. There's nothing great in it. It's already existing. Along with that, and this is where the mischief comes in, it's called the EFIR, electronic FIR. Now it says that you can give an EFIR. But they put a condition there. If I send from Dum Dum a complaint that so and so people came and beat me up in an APDR meeting, okay, I can send it by email. But the law now says within 3 days of sending the complaint, I should download that email, sign it, go to the jurisdiction area and give it within 3 days. If you don't give it within 3 days, the complaint will be thrown out. Okay, so much so for EFIR. Okay. So everywhere they seem to be giving us some improvement. Actually, they're pulling out all the protections that we have. That is insofar as the complainant is concerned. Now let us look at the other side. I give a complaint against somebody. They are the accused. What is the procedure to be followed there? The procedure there says now that if the police feels the complaint is correct, they should be arrested. Okay. Now they have introduced 2 very, very dangerous provisions in the law. One provision says, or rather three provisions they have introduced, extremely dangerous. If the other person is arrested and they are taken by the police for investigation, the law says that the police can ask for the custody of that person with themselves for investigation. That is called police custody. Okay? That's called police custody. The law says, the current law 173(2) says, you can give police custody for a maximum of 15 days. Only 15 days you can give. Then the question is from when? The registration of FIR or date of arrest? Okay. Now, generally talking, it's one thing. But if you are the arrested person, every day in police custody is dangerous. Okay. The police custody will start from the date of the arrest. Now, there is one problem here. Everybody knows, all civil liberties people know, APDR people will know. The torture takes place not only in police custody. Actually, the torture takes place before police custody. Before you are remanded. If they arrest you today, for 1 week they will keep in the police station, beat you up. You will become like chutney. Then you will say black crow is a red crow, you will be beaten up so much, you will say yes. Okay. So the problem is between detention and showing remand. This has been a demand of the human rights movement for a long time. Make the police accountable from the time of detention until you are shown to be arrested in the particular complaint. The government has not come with any rectification on that part. Instead, what they have done now is that police custody of 15 days, now they have changed. How have they changed? They say, now earlier law, the law until tomorrow is, if you are granted 15 days police custody, supposing I am arrested on the 1st, the police say, these guys threw stone at an APDR meeting, very, very serious. We have to find out who is behind them. So we need 15 days custody. The judge will say, no, I won't give you 15 days, I'll give you 5 days. The sixth day, the police will have to go back and ask them, I need another 10 days. Out of the 15 days, 5 days is over, 10 days is left. Give me custody for 10 days. The court will say, I'll give you only 3 days. And then once again, they'll go back and say, there's 7 days left. You have 5 plus 3, 8 days, 7 days is left. I need 7 days time. Court will say, I'll give you 2 days. So 5 plus 3, 8 plus 2, 10 days. 10 days is over. The law as it is till tomorrow says 15 days maximum you can ask for 3 times for the police. After that, the court has no authority to grant police custody. You have to send them to judicial custody. Judicial custody means you have to go to the central jail. Some amount of protection when you are in the central jail, not in the police custody. Which is why the law says from police custody only maximum 50 days from the date of arrest. You cannot change. Friends, they have tinkered with this in 2 very serious ways. Now they have said, even though you may have been granted judicial custody, at any time the police can be granted police custody. Supposing you have been in police custody for 10 days and then you are sent to judicial custody. After 15 days, the police will say, give me, we need them more time for, okay, and they'll take. Normally during police custody, they beat them up and get confessions. They'll get whatever evidence they want for themselves. Okay. So, now until tomorrow, after judicial custody, you can't ask for police custody. From day after tomorrow, after judicial custody, you can go back to police custody, go back to judicial custody, go back to police custody. So now it can vary anytime this way, that way. Problem comes. You can get bail only if you are in judicial custody. Okay, so after 10 days, the court gives you judicial custody. You file for bail and the court grants you bail. But now the law says police custody can come back again. If you are arrested, if you have got bail and you are out, you can be arrested back again. Because the law now says police custody at any time. I hope you understand what I am saying. This is extremely serious. Because without this power, the police is doing so much. With the power, what are they going to do? That's one. Bigger mischief is that in section 173, they have brought about a huge change. The law as it stands till tomorrow says, the court can grant custody otherwise than police custody for a period of 60 to 90 days. What it meant is that police custody is 15 days, after which you have to go to judicial custody. In the new law, they have taken out this other than in police custody. They have removed that 8 words. They have kept the same old CRPC provision. The meaning will be, police custody is now no longer limited to 15 days. Legally, police custody will be for a maximum of 60 days for smaller offences and 90 days for bigger offences. Imagine the plight of people who are arrested. Imagine the plight of people on whom political cases are being filed. So this 15 days remand has been removed and you can be granted custody. This is hugely problematic. It's something, it is now the law of the land. Okay, and it's dangerous. Now look at 2 other things they have brought. Till now, handcuffing is not compulsory. To the contrary, based on rights-based approach, handcuffing, the rule is that every time the police want to handcuff, they have to get permission from the judiciary. They have to give reason why, and only then they can put handcuffs. Now, so in the law till tomorrow, handcuffing was the exception. Not using handcuffing was the rule. Now, from Monday, handcuffing is the rule. Not using handcuff is the exception. Which means they arrest somebody from here and go, they can very well put you cannot say I am a lawyer, I am an academician, I am X, Y, Z. Nothing. They have the right. The power has been given to them in the law. Handcuffing is now an authority with the police. The other part is that anybody who is arrested, the name and details of the arrested person till now, till tomorrow, had to be displayed in the police headquarters on a daily basis. Okay. So that if there is some problem about somebody being illegally tortured, the family members of the lawyers can go and check out. What they have now said is that they will have to be put in digital mode in every thana in the country. Which means if I am arrested tomorrow, the police inspector will have to put my name in the digital form in the police station. Now with WhatsApp University, fake news, fake factory, you can imagine what it will be. Already in Uttar Pradesh, Madhya Pradesh, they put up the name of people who are protesting against CAA in the big billboards. You know what happened 2 years back? Across Lucknow, across Allahabad, they put all the names of people there. Crowd of the Hindutva group went to a house of every Muslim community person and demolished the house. Now take honor crimes. SC, Dalit and non-Dalit crimes. I don't know how much of it happens in Bengal. It's a big issue in the south. It's a big issue in the west. In Rajasthan, Gujarat, Maharashtra, Punjab. Honor killing is a big issue. Hate crimes is a big issue. Imagine if somebody name is put up in the digital mode and it goes around, what the mobs will start doing, right-wing mobs will do. This is the law that is now going to come from Monday. That the details of the persons arrested should be available for free display with anybody. PUCL has given a strong rejoinder saying, this is tinkering with the very heart of the criminal justice system. This is a dangerous change. You cannot allow this change. Okay. This is with regard to arrest. So we have seen complaint from the viewpoint of the complainant. You looked at what happens after the complaint from the viewpoint of the accused. Now let's look at investigation. During investigation, till now, the power has been given to the police to do investigation, but the oversight is given with the judiciary. The magistrate has to look into it. They've changed this law. They say, for example, there is a provision that says, not just the accused person can be asked to give handwriting samples, voice samples and other things. Any person can be forced to, or can be directed to give samples for investigation. Now, till now, the law said, any person means a person who has been arrested in that case. Supposing I have been arrested in the case, I have let out on bail. Tomorrow the police wants to check my voice sample with the sample. Although I am on bail, but I am arrested, then they can direct me to give sample. What they have done with the new law, they have kept the same CRPC provision and put a provision, an explanation there. It's called proviso to proviso, technical. They have said that may be the law till 30th of June, but from now on, you don't need to follow that law. Any person means any person. So any person can be compelled to give evidence against themselves in the name of investigation. That is investigation. Now let's come down to charge sheet. Okay. So these are the stages in the crime: complaint, arrest, investigation, charge sheet, and then trial. I'll stop at that point. So even in terms of that provision, in terms of the charge sheet, the law now says audio-visual evidence can be given. Now the question is, what type of audio-visual evidence that you want to give? The audio-visual evidence can be anything, including your WhatsApp messages, your emails, anything that is in your computer. Now we now know what happens when everything from the computer is taken. Bhima Koregaon case is there. Okay. Now they should also then give a protection from the police from using your material wrongly. Deliberately, they have not provided any protection for us when our electronic details are taken. This has been a demand for the last 3 years. To the contrary, full power is given to the police to come and take any electronic evidence from you without putting a condition that when I take your laptop, I take your phone, I take your hard disk, there's something called a hash value. That is, as of today, if I'm using a particular, say I'm using a Word document and I save the document as of now, there will be a separate value. 5 minutes later, I open the document, I resave it, it will have a different hash value. Deliberately, this law does not provide any protection or any accountability on the police to say, when you take electronic evidence, you should give a copy to the person from whom you're taking. You should also give a hash value to that. Okay. So this is at the time when charge sheet, when evidence is being taken. Then comes the last part. During trial. Till now it says, if somebody is absconding, is not available for trial, they run away, for example, then there are, say, 5 accused. 3 accused are attending regularly, 2 accused are not attending. The 2 accused will be declared to be not coming to the court. They'll cut off that case from the other person and they'll proceed with the trial of the first 3 people. Supposing the trial is over, whatever is the verdict, then later they find the other 2 people, they will be brought again. Trial has to be held again. That is the law till tomorrow. This is based on a very basic fundamental constitutional principle that you shall not hold a person guilty without giving them a chance to oppose the charge against them, even though they may have run away, even though they may have absconded. That is the principle of law. It's called audi alteram partem. Give the person a chance to oppose the request of the police. From day after tomorrow, the law of India says that if a person is absconding or not attending court, the police may declare him as a proclaimed offender and conduct the trial in absentia. Which means even without the presence of the person, they can go ahead with the trial, okay, and hold the person guilty or acquitted, whatever is the thing that is coming. Now, this is very dangerous. Supposing I am that person who's, many times it happens that I don't even know that my name is there in the charge sheet. I don't even go there. I come to know 1 year later, by the time the trial is over. I can't go to the court now and say, look, on the day the trial was over, I was not there. Please conduct the trial again. Till tomorrow I can do that. From Monday, I cannot do that. Because the law says, if I am not available, it can be taken over. It will be concluded. Now imagine what is the type of problems that's going to be caused by this. Particularly in the cases of gender crimes. Particularly in the cases of very marginalized, poor societies who don't have access to good lawyers. Particularly in the case of people who are living in rural, distant areas. In absentia trial kills the core of the constitutional principle that nobody shall be held guilty without giving them a chance to defend themselves. In one shot, the constitutional fundamental right has been taken away. In a way, if you look at these changes, it looks like the government called a set of policemen and told them, you tell me all the problems that you have with the current procedure and we will give you the solution. All the problems that policemen have had, they say, we'll now pass a law, throw that out and we'll make that the law of the land. Friends, that is how these amendments are. I'm giving it in a very simple form. There are a lot more technical details I'm skipping because for a general audience it may not be very easy to understand. So the heart of it, from all the 5, from complaint to accuse to investigation to charge to trial, the entire system has now changed in law to make it totally police-centered. Which is why PUCL statement says, from a de facto police system, it has now become a de jure police regime, police state. That is, where unofficially it was a police state. I'm sure I'm hearing so much about Kolkata, about West Bengal. Elections are a different matter. The type of human rights abuses that are taking place in West Bengal, okay, and the type of role that the police is playing in Bihar, take anywhere. Here there is nothing ruling NDA, India, nothing. All I come from Tamil Nadu, where massive human rights offences are going on. That you fight against Hindutva thing is a different matter, but the human rights abuses are taking place. In that place, giving so much power to the police, what is going to happen in the future? Everything is now given to them, and everything which has been given to us has been taken away. Okay, that is why we are now saying legally they have now made India, or they're going to make India from Monday, 1st July 2024, what was an informal police situation to becoming a formal police state. That is the danger that is confronting us. This is from the viewpoint of, looked at from the criminal procedure. I know I'm taking a little more time, I'm sorry. I'll try to make it short. Now let us look at the crime part. Okay. I've talked about procedure. If procedure is so bad, what about IPC? What have they done to the IPC? And what you will see there is something much, much more horrible. Okay. There are 3 key sections they have added, which is going to make meetings like this dangerous. The first and the foremost thing is they have made terrorist act which is part of Unlawful Activities Prevention Act. Okay. Part of the ordinary penal law of the country. Till now, Terrorist Act was a separate law. It was not part of the Indian Penal Code. From Monday onwards, the new Indian Penal Code now has a provision in section 113 of the Bharatiya Nyay Sanhita, where Terrorist Act will now become the law of the land. Now, why is this such a dangerous? It is dangerous for two things. One, terrorism by its very meaning means that it is a set of people who indulge in political crime against the government to overthrow the government. In ordinary parlance, that is the thing. Supposing there are two gunda gangs, they are fighting with each other. Both of them have machine guns. Okay, gang A, gang B. They come to the marketplace and they shoot. It's a fight amongst them. If they shoot with each other, they also create terror. People get terrorized. People will run away here and there. 15, 20 people may die. What is the difference between that gang terror and political terror is a question. I hope I'm making sense here. This is important for us to understand. Please show your hands. I hope you're clear. Terrorism by its definition means it is against the government. It's against the government. It's to overthrow the government. Okay. So terrorism does not mean body harm. Terrorism does not mean I'm creating an injury on him. Terrorism means that we are all coming together to overthrow the government, to make India an independent country. We don't believe in this constitution, throw out the constitution, or to secede from India. That is a terrorist crime. The Supreme Court 20 years back, when they looked at Tada, said gangland fights may take place and people may use machine guns and kill a lot of people. That is not a terror crime. Okay? Terror crime is only when the action is oriented in a political sense against overthrowing the country. Okay, this is the ordinary meaning of. Now, based on this, you had originally Tada, subsequently you had Pota. Tada was a horrible crime law. Many of us fought. I was part of the movement in the 90s to fight against it. Nobody thought we will force the government to throw out Tada. Tada was a temporary legislation. It had to be renewed every 2 years. Tada in 1997, we forced all the human rights groups came together, including APDR, came together to demand that Tada should not be renewed, and they dropped it. Then Tada gave place to Pota. Pota again in 2004, pressure of people, they removed it, but they brought it in as UAPA. Now see how the state is arming itself. Tada 2-year law becomes Pota after the parliament attack in 2002. Pota is dropped, brings that as UAPA. The progression from UAPA, it has now come into the penal code. That's a progression. Okay. So why it is dangerous is that the definition of terrorist act, there are only 2-3 things I would like to point out to you. Is that it is not an act only threatening the integrity, national interest, sovereignty of the country. Any act which threatens economic security is a terrorist crime. What does economic security mean? Tomorrow, a polluting company is going to come in the outskirts of Kolkata. And you all decide, this is a very, very destructive company. We should not allow this to come here. And you all decide that you're going to have a protest. The government will say, you are preventing growth, economic growth, by preventing that company from coming. You are therefore affecting the economic security of the country, and therefore you are not creating an ordinary crime, you are creating a terrorist crime. And they'll put you in under section 113. Now you have 113 in the new penal code. You also have UAPA. The problem is, what if both acts are taken into place? Okay, it's a legitimate question. Now let's look into that question. So any act which threatens national interest, etc., also threatens economic security. It's so wide. Anybody can be brought into that offensive. Don't think that I'm giving you a horrible picture. Already 8,000 people are in jail under UAPA. PUCL has come out with a study. Only 2.8% is the conviction rate in Tada cases, in UAPA cases. 8,000 people between 2015 to 2020. Now data is not available after our report came. We used details from NIA. 8,600 people were in jail for minimum of 5 to 8 years with trial not starting. Only 14 to 18% people get bail. People don't get bail once you go to UAPA. This is a track record of UAPA. Now, from being a special law, you have now made it part of the ordinary criminal law of the country. Okay? This is the danger when you make it so broad and so wide. Now, let us look at two things. In UAPA, was there any protection given for abuse of power by the police? One question. Two, in the new penal code, where have they used this section 130? Now, friends, here comes the cunningness of the government. Section 113, the new law on terrorist act in the new penal code, has been included in a chapter of the new penal code called offences against the human body. This is chapter 6 of the new penal code. Chapter 7 of the new penal code is offences against the state. Should we as citizens, not as lawyers, as common sense, will terrorist crime be an offence against the state or will it be an offence against the human body? You don't need to be very learned about this. A terrorist act can never be just an act against the human body. It is an act against the state. But they have included section 113 in chapter 6 of the penal code. Then the next question comes, why did they do this? Friends, they have done it for a very important reason. Any offence under chapter 7, offence against the state, no court shall take cognizance of that case unless the government gives special sanction to prosecute. That sanction to prosecute you can challenge in the court. That is for crimes against the state. So if you put terrorist crime in chapter 7, the next chapter, then the law says you have to get sanction to prosecute. I am not again getting into nitty-gritty details. Any of you have any doubt, I can explain to you. But this is a simple thing. You cannot, no court can take cognizance without special permission from the government. It's called sanction. But for offences against the human body, such sanction is not required. So once they've put you under 113, sanction is not required at all. You can just be put in and thrown inside. You will never ever get bail. For 3 years, 5 years, 10 years, whenever the courts wake up and then give you the thing. So that is one important legal accountability which has been stopped. There's a second and an equally dangerous implication. Under the UAPA, many human rights groups opposed both the UPA government and the NDA government. And with the UPA government, we all fought against them saying, you're repeating Tata and Kota into UAPA, this is not right. We forced Chidambaram and company to come up with an amendment in 2012 or 13, which said that when the investigation is completed in a UAPA case, the government has to create an independent committee, independent of the government, independent of the police. The evidence gathered should be sent to them. Within 14 working days, that committee should look into the evidence and say, is the terrorist crime made out or not? If the crime is not made out, they can say, the government should not give sanction, the case will end there. But if they say the government can give sanction, it goes to the government. Government will study the charge sheet, will study the report of the special committee, independent committee, and within 7 working days, now this is important. I won a case where it was the 8th working day, which means they have broken that 7 working day. There's a reason why they put that clause. The government can say, I agree with the committee or not. So there are 2 levels of protection of abuse of the UAPA. In the new 113 provision in the new penal code, this provision has been dropped altogether. Why have this problem about giving a provision counting 10 days, 12 days, 14 days or 15 days, 15 days from when Saturday, Sunday will be used, counted, all this problem. Why have that problem? Throughout the clause, they've removed that. So in effect, it is like locking you up in the station and throwing the key away by introducing terrorist act in the penal code. There's one more dangerous provision they've added. And they've said, sedition. Amit Shah claimed in parliament, we are such a great group. Jawaharlal Nehru in 1952 in the first Indian parliament said, sedition law should not continue in independent India. It has come, but before the end of first parliament, we will throw out sedition. He did not do it. So now you know how Amit Shah and Modi are constantly attacking Nehru. You know that sub-story that's happening. Now they are claiming Nehru did not remove sedition. See, we are so great. We have removed sedition. That is the claim in parliament. It's not my claim. I'm not giving you a clever twist. The claim of the government is we have repealed or we have dropped sedition. They did not tell the nation. They brought sedition in a new character in section 152 of the new Indian Penal Code. The same sedition law has come again in a new avatar with more stringent conditions and no protection at all. Just like Terrorist Act, no protection at all. In the new act, apart from saying whoever purposely or knowingly. Now, what do you mean by purposely? What do you mean by knowingly? Very big problem. Okay. So, if you are now going to continue to write, Suresh came and told us that 113 in new penal code is against the government. Government is now a terrorist. Will you be under purposive or will you be knowingly doing it? Or are you communicating something for a discussion? All this will become if from now on, from Monday onwards. Then they say, who attempt to excite. Who attempts to excite. What does excitement mean? If I am a good speaker, I can make you jump. If I am a dull speaker, I can make you sleep. So is it the problem of the speaker or the problem of the reaction? How do you measure excitement? The law says who attempts to excite or attempts to excite. There is no definition of what attempt to excite means. I'm talking, friends, I'm talking from the section 152. And then it says subversive activities. What do you mean by subversive activities? Not clear. Then they say encouraging feelings of separatist activity. Feeling, you are encouraging a feeling of separatist activity. What does feeling mean? How do you measure feeling? For example, the South. I come from Tamil Nadu, the South. The South has been strongly feeling we have been able to limit our population growth. So our population levels are much lower than, in fact, replacement population has now come down beyond the threshold in Tamil Nadu, Karnataka, Kerala and Andhra. We are contributing maximum revenue to the government in GST and other direct and indirect tax. Now delimitation exercise is going to come in one more year time. They are going to change the number of MP seats. Because we were successful in family planning, because we were successful in education, we were able to limit our states into a thing. Therefore, we have less number of people. Now, should you reward this or should you punish it? The delimitation exercise is going to punish us by giving us less number of MP seats. It's going to reward Uttar Pradesh, Bihar, Madhya Pradesh, Rajasthan, Haryana, and the other northern states. Because their population is growing. They'll get more MP seats than us. Already, it's a north versus south divide is very sharp. Now it will become completely like two different things. So during the election, many people in the south were talking, we should now, this is not a united India. This is an unfair India. We should now talk about going separate. You would have read about it 1 month back. This was part of the election discussion. Now, if you were to talk like that, or you are going to write an essay like that, it will become subversive activity and you are exciting feeling. Okay. Imagine a policeman given this power, exciting feeling. There's no end to it. Nothing, no definition at all. What is excitement? What is feeling? What is subversive activity? Nothing has been given. Now, original sedition law said life to 3 years. The new law says life to 7 years. They increase the punishment. Okay. So, friends, I will stop here because it's taking a long time. There are two small issues again which are very problematic. Hunger strike. All of us are in the civil liberties movement. Many of us have been part of hunger strike, 1 day strike, 2 day strike, sometimes indefinite hunger strike. Why do we do hunger strike? Not for fitness. We are doing hunger strike for a political reason, that we want the government to do or not to do something. Now, there is a new provision in section 226 of the new penal code, which says that if you go on a attempt to commit suicide for the purpose of making a government officer do or not do something, that becomes a new crime. And you can be arrested and put inside. Till now it was nebulous, it was not clear. Now it's become very clear, it becomes a crime. So, like this, a number of other things have been put together. On the issue of marital, 3 crucial issues. So nice to see so many women here. Please don't think I'm being paternalizing about it, but just that many other meetings, I don't find too many women groups coming into that. Three very important things have to be kept. The women's movement has been demanding for the last 30 years. Marital rape should be recognized as an offense. They've been demanding it for a very, very long time. This government, in this new law, has deliberately continued what was there in the IPC earlier, saying that any husband who forces sex on somebody who is 18 years and above cannot be accused of marital rape. So what was not said clearly earlier has now been said properly. Marital rape is not a crime in the new law. It's a law. Okay. So that is on the gender issue. Let's look at the second part of the issue, which is that of adultery. Supreme Court said in the Joseph Shine case in 2017 that adultery where a man has an affair with the married woman of somebody else, then that will be adultery. You can file a case against him. Supreme Court said this is a very patronizing, patriarchal attitude towards marriage. In a modern period, this is not something that you can take. A woman is not a property of the man, even though she may be the wife. And they struck down adultery law. What does the new law say? While that section 394 of the Indian Penal Code has been dropped, 398 of the Indian Penal Code, which talked of the same thing of adultery in a new way, they have retained and brought it now as a new law. That any man whose wife has had an affair with somebody else, that man can be arrested. So they brought back adultery by the back door. So one, marital rape. Second thing, and let's take the third thing, which is that of unnatural sex, the so-called unnatural sex. Sex between same-sex people. Okay, section 377 was struck down by the Supreme Court. But the Supreme Court said, we are striking down only part of section 377. That is LGBTQ, crime, sexual activities between consenting adults of the same gender. Okay, the Supreme Court said, we recognize it has to be struck down, but we have to balance out that between partners of the same sex, there can be violence, just like marital rape. There can be rape of a man by another man, or there can be a rape of a transgender by a man or by another transgender person. That also is rape, because the index is not gender. The index is force. Index is consent. So when force and consent are taken away, that is a crime. That's the basic principle. So what the Supreme Court said very clearly and unambiguously, this government has brought back by completely knocking out that law. So as it is from Monday, rape of a man by another man, rape of a transgender, there is no law giving them protection. You cannot go to any police station and say, I need protection. The law has been removed. What was there as judge-made law in the Constitution has been removed. Just to tell you how serious it is, you will remember just 6 months back when the Supreme Court struck down the law appointing the Chief Election Commissioner and Election Commissioner. You all will remember that happened. Supreme Court struck it down. Within 3 or 4 days, government came back with a new law in which they removed the Supreme Court said it has to be a 3-member committee consisting of the Prime Minister, Leader of the Opposition and the CJI. They came up with a new law. They removed the CJI. And they said it shall be the Prime Minister, the Law Minister and the Leader of the Opposition. In the Lok Sabha. You will remember that. Okay, this happened just 4-5 months back. Okay. So by a stroke of a pen, the government can throw out what the Supreme Court has said. And in the new laws, at every place where protections were given, those protections have been removed. I'll stop here, friends, and say, when you look at this in totality, it is a little difficult because one section here, one section there, one provision there, one subsection there, that's what they have done. What I have sought to do is to put these things together, to show all the dots, and I've connected all the dots. I have a paper which we have shared with our friends in APDR. Any of you want the paper, you can kindly take it from them. Okay, it's meant for all of us citizens to know. Where all that I've told you now in a story form, actually all the words are there, the sections are there, the old section, the new section, all of that is there. My request to you, please read it. Please read it, because we don't have the luxury of not reading it. Because our fate, the fate of our country and the fate of the ordinary people now rests with us. How conscious we are, how willing we are to take a stand. Because the poor and the marginalized of the country will stand up and fight. They showed that in the elections. They did not give majority to the right-wing BJP group. They showed it. The people of the country defeated the right-wing forces. It is up to us, the educated group, up to us, the human rights activists, the concerned citizens. It is up to us now to repay our debt to them. Because these laws are going to affect them more, apart from affecting us. And therefore, we need to come together. Which is why, in the eyes of the PUCL, we say that these laws have not been brought about by poor draftsmanship. It is not somebody who didn't know the law. It is not somebody who was not good in grammar. That's also, many times people say, it is a bad draftsmanship. Somebody who didn't really know the law. This is not poor draftsmanship. This is very deliberate, cunning, and thought through amendments that have been brought. With the only intention, whatever protections we had should be removed. And however the police can be helped to strengthen, which means the political executive's hands are strengthened, should be strengthened. Which is why we now have in law a police state. The challenge before us, are we going to keep quiet or are we going to fight? Thank you.